earlier in point of time, the appellants are entitled to be fixed in the vacancies kept reserved for them in the placement numbers 28 to 33. In that regard, he contended that once the appellants have been appointed substantially by direct recruitment, they should rank senior to the officiating promotees, and therefore the High Court has committed serious illegality in not giving the direction in that behalf. Having given our anxious consideration to the contention raised, we find that on the basis of the rule position, it is difficult to accept the contention. The language caused in Rule 2B of the Tamil Nadu State Higher Judicial Service Rules 82 would make the matter clear that the appointment to Category 2 of the decision is from two sources, namely recruitment by transfer from the cadre of subordinate judges in Tamil Nadu services or by direct recruitment. While making a recruitment, the proviso limits its operation out of the cadre. Not more than 10 posts shall be filled or shall be reserved to be filled by direct recruitment. It does not indicate that this is meant to be up to a maximum of one-third post of the cadre. Had the percentage of posts been linked with the total cadre strength, certainly direct recruits are entitled to occupy one-third of the posts from the date of their officiation and get seniority from the date subject to successful completion of probation, irrespective of the fact whether the promotees have been continuously appeared in distinct positions prior to the appointment of the appellant in excess of their quota. Their earlier promotion and continuance would not ensure to their advantage, and they will be pushed down, giving place to direct recruits within the quota reserved for them. Unfortunately, Rule 2B does not prescribe any quota. It said not more than 10 shall be filled by direct recruitment. If that is the language, it should not fix a quota. Here it is not more than 33 and one-third percent, means it could be anything less than 33%, 33 and one-third percent. It could be 0% also, but it does not mean that any quota is there in their favor. It is a permissive exercise of the discretionary power of the High Court and not 33% definite quota for in favor of the reserve, in favor of the district direct recruitment. It would mean that at no point of time, direct recruits would exceed 10 in number. Undoubtedly, the object of direct recruitment is to infuse young blood into service to accelerate efficiency, and members of the bar opt for selection by direct recruitment with an object to get elevation as High Court judges. To achieve the purpose, the language of the rule should be different. Some our rule says not more than 33 and one-third percent. Therefore, it is untenable to contend that High Court should work out the quota from the 1983 rule, calculate how many direct recruits were there, how many promotees were there, and then fix their seniority. No. In 1983 rules, there was no quota prescribed, but an outer limit of 33 and one-third percent was granted to the direct recruits, subject to the discretion of the High Court. Suppose the High Court determines the vacancies to post to be filled by direct recruitment as 2, it can be 2 only. Suppose it says 10, it is 10, subject to the condition that it shall not exceed one-third of the total cadre strength. That is the plain and simple meaning. And this rule came before for interpretation before a learned single judge of this honorable court. Unfortunately, that judgment was also not placed before the division bench in the edition. That is the next, that is the MS Shambling up. Judicial service is distinct from civil service. Karnataka Judicial Service Rules being comprehensive and Karnataka State Civil Service Act being general in nature, the comprehensive rules will have to be applied to the judicial service. At the same time, two statutes cannot be made applicable to single service, that is judicial service. Hence, the first point is answered in the negative. That is, the question was whether the rules applicable to the state civil services will apply to the judicial service also. The answer was given as negative. Next point for consideration is whether the Karnataka Judicial Service Rules provide for any quota for direct recruitment in the cadre of district judges from the bar. This is 2003 judgment when 1983 rules were in force, because 2004 rules came into force on 9th September 2005. I'll take my lords to that rule a little later. The method of recruitment to the post of district judges in schedule to Rule 2 of the Karnataka Judicial Service Rules reads as under: district judges by promotion on the basis of seniority cum merit from the cadre of civil judges, provided that such number of posts as may be determined by the High Court from time to time, but not exceeding in the aggregate 33.13% of the posts in the cadre of district judges, may be filled by direct recruitment. This is the rule that came up for interpretation. This rules providing for filling up of the district judges post by promotion by selection, not exceeding 33 of the posts in the aggregate could be filled up by direct recruitment. For that purpose, the High Court has to determine from time to time the number of posts in the cadre of district judges. In other words, out of the total number of posts to be determined by this court as per the schedule to the rule referred to supra, direct recruitment could be adopted up to a maximum of 33.13% or posts or one-third of the total number of posts. Thus, there is no fixed quota for direct recruits, while maximum limit is prescribed. This is the finding recorded by the single judge. Of course, there also the Supreme Court judgment has not been referred, but it accords with that judgment of the Supreme Court. Both these were not brought to the notice of the division bench, because for some of the promotees I appeared in that round also. I am also equally guilty. But then there my purpose was served by saying that from the date of occurrence of the substantive vacancy you give, and I was admittedly on the day I was promoted, I was a fast track judge. Therefore, I did not think it necessary to bring it. Ultimately, that was the concession. Then, my lords, I say that these two judgments were not brought to the notice. One binding a precedent, another is a persuasive judgment. Then, my lords, a lot of arguments have been advanced on what is the cadre strength. Whether cadre strength has to be by a notification alone, or cadre strength could be something which can be inferred also. No, my lords, so one submission I would like to make here is, apart from the number of courts that are in place, there is what is known in service jurisprudence as leave reserve and deputation reserve. We cannot expect, my lords, any district judge or for that matter any advocate also to be coming to the court on every working day. Certain leave of absence fixed by service rules is available for judges. Then, my lords, of course, for us it is permissive, that is different. The judges are always governed by the rules. Therefore, in every cadre, there is what is known as leave reserve. I'll point out from the notifications produced by the petitioners themselves that the concept of leave reserve and deputation reserve is there even in the cadre of district judges. Insofar as number of courts and number of judges, it is common sense. If the government sanctions establishment of one court, there have to be one judge. And as Lordship Justice Krishnaiyer put it in SP Kulashrestha, common sense is not enemy of court sense. This is the phrase deployed by Lordship Justice Krishnaiyer. The question there was, for the post of lecturer or associate professor in assistant professor those days in a university, qualification prescribed was high second class. The matter went up to the Supreme Court to decide what is the meaning of high second class. It was not stated anywhere in the rules. What is the meaning of high second class? Lordship Justice Krishna found a common sense answer to it. He said, if 50% is second class and 60% is first class, anything above the midpoint is the high second class. Therefore, you can treat a person as high second class if he is anywhere between 55% to 59%. After saying so much, he said, common sense tells me this, and court sense is not enemy of common sense. One court is there, it cannot function without one judge. Sometimes courts can function without stenographer also, but not without a judge. Therefore, if 318 or 314 courts are there, and as long as there is no allegation that High Court has established a court here without the sanction of the government, 314 or 318 posts are required to be there. I'll come back to that a little later, further as to how they reason. Then kindly take the 2004 rules. 2004 rules, before that, at page 703, before the 2004 rules, page 703, 704 is the 2004 rules. Let us just have a glance at page 703 for a moment. This is the notification dated 3rd March 2001, produced by the petitioners themselves. It says, typed copy at page 703 may be referred. In supersession of all the existing orders, the government of Karnataka hereby sanctions the establishment of state service cadres in respect of district judges and the Karnataka Judicial Service. Strength of the said cadre and the number, character of posts borne thereon shall be as follows. Item 2, district judges, 33 plus 2 leave reserve. Then temporary 23 posts. Then deputation reserve 46 posts. This is what they say. But forgetting about the figures, one thing is district judge cadre consists of not only the number of courts, but leave reserve and deputation reserve also. My lords ask a specific question. Suppose somebody is deputed as additional registrar of inquiries to Lokayukta. What happens when he comes back? When he comes back, if immediately there is a post, they will post, or they will post him on OOD. But kindly remember, when he was promoted against the deputation reserve, which is a part of the cadre strength. And there could be a permanent member of the cadre against a temporary vacancy also. Factually, did they? Where he is sent is not relevant, because point is he is regularly promoted. Then instead of posting him to a district court or additional district court, he is sent to the Lokayukta. It is against a deputation post. Nonetheless, it is a cadre post. Appointment is within the regular cadre strength, because the cadre strength notification itself specifies there are 46 deputation reserves. There is also even suppose some district judge regularly promoted. He may be in a super time scale also. Some suspicion arises about his conduct, or some vigilance inquiry is going on. Then what the High Court will do on the administrative side? He will be removed from regular court. He will be placed as OOD. We have any number of such examples. I don't want to name them. Some of them are good, my good friends after coming this side of the uh, uh, divide. There can be a regular, and there will be a regular judge only, regularly appointed judge only, even for leave reserve or even for deputation reserve, because it is part of the cadre strength. Yes, ma'am.
They have X number of district judges,
Yes.
out of which some vacancy has arisen, or there is a requisition by the government. Let's say they want an additional post, additional law secretary to,
Yes.
and that is they say we want one more district judge to be.
Yes, Manoj.
Then the High Court then sends the district judge either from leave reserve, whatever available strength, to that post. Government passes a notification before he sent. Now, is this an additional to the cadre strength or merely sending somebody who's
No, it is an addition to the cadre because there must be a district judge who is holding the post substantively and who alone can be deputed. Suppose additional law secretary. Cadre and recruitment rules for additional law secretary says one district judge by deputation. Then it cannot be filled by ad hoc district judge on deputation. There are any number of judgments of this honorable court. Now, my lords, take this case. In Public Works Department, there was no promotion to the cadre of chief engineers, or for that matter, even executive engineers or assistant executive engineers, for about 8 or 9 long years because of this Seniority Reservation Act, and then several disputes were there. All the posts were being held by Rule 32 persons. Rule 32 placement in independent charge. Suppose a superintending engineer is there. He cannot be promoted for some reason. Then he will be put in independent charge of the post of chief engineer in the interest of service, public service, and he will be required to perform the duties of the chief engineer. The question came before this honorable court. Now KADB is there. In the KADB, there is a post called as Chief Development Officer. Recruitment rule says Chief Development Officer method of recruitment is by promotion of Deputy Chief Development Officer or by deputation from Public Works Department of a Chief Engineer. Instead of granting promotion to the candidate available in the department, what the KADB did was, it took one Rule 32 chief engineer from the government on deputation. That was questioned. This court said that a Rule 32 chief engineer is holder of the rank of a superintendent engineer only. He does not hold the rank of chief engineer. Therefore, the post of Chief Development Officer in KADB cannot be filled by deputation of a Rule 32 Chief Engineer. That was confirmed by the division bench. I'll place that judgment for my lord's consideration if it becomes necessary. Note down. T.R. Swami. Matter has there are 2 cases. Therefore,
we have anything called cadre recruitment rules and so far
yes, my lord.
district judges.
Cadre and recruitment, about the cadre strength, my lord. Cadre strength, what has happened is this, my lord. If my lords would kindly take KCSRs, I'll point out how that concept works out. In the KCSRs, Rule 8 deals with the definitions. And KCSRs are applicable to district judges because I pointed out from the recruitment rule itself. General recruitment rules, yes, some of them will apply, some of them will not apply. Sub-rule 7 of Rule 8. Cadre means strength of a service or part of a service sanctioned as a separate unit. So according to this, cadre strength means number of posts in the cadre, no requirement of any notification. Requirement of notification came by virtue of the Karnataka State Civil Services Act, and after 2001, even that requirement has been taken away. See, what is happening is this, Manoj. If my lords would recapitulate, before 1978 Act came into force, the position was under Article 309, a rule will have to be made only in respect of method of recruitment, not about the number of posts. Number of posts were always determined by executive orders. I'll just take my lords to Article 309, then I'll take my lords to the Karnataka State Civil Services Act. (309). Recruitment and conditions of service of persons serving the union or a state. Subject to the provisions of this constitution, acts of the appropriate legislature may regulate the recruitment and conditions of service of persons appointed to public services and posts in connection with the affairs of the Union of States. It did not speak of creation of a cadre or number of posts in the cadre or pay scale. Pay scale could perhaps be linked to conditions of service. But insofar as the establishment or creation of a cadre and the cadre strength, there was no requirement under Article 309. Provided that it shall be competent for the president or such person as he may direct in the case of services and posts in connection with the affairs of the union, and for the governor of a state or such person as he may direct in the case of services and posts in connection with the affairs of the state, to make rules regulating the recruitment and conditions of service of persons appointed to such persons to such services and posts until provision in this behalf is made by or under an act of the appropriate legislature. Now, until 1978 Act came into force, Karnataka State Civil Services Act, there was no law made by the legislature. Therefore, governor would make the rule of recruitment, pay scale, and method of recruitment. That rule would not contain anything about either creation of cadre or strength of that cadre. Therefore, until this 1978 Act came into force, the procedure followed was On the same day, 2 notifications would be issued by the state government by and order in the name of the government. One notification creating the cadre and mentioning the cadre strength and pay scale. And another notification, which is the rule made under Article 309, stipulating the name of the designation of the post, pay scale, and method of recruitment. This was the procedure followed. Creation of cadre and prescription of cadre strength is by executive instruction. Prescription of pay scale and method of recruitment is by rule made under Article 309. This position underwent a change when 1978 Act came into force. Now, my lords may take the Karnataka State Civil Services Act. That we'll see. That the bench has no difficulty. No, my lords, this act came into force on 10/12/1991. Sorry. This came into force on 13th May 1990. About 12 years hiatus, because it required presidential assent and all that. Therefore, it was held up. Now, Section 3 of this Act may kindly be seen. Regulation of recruitment and other conditions of service. Subject to the provisions of this Act, the state government may by notification, this is where, my lords, the word notification has now crept into this cadre strength. My endeavor would be to say that this has been made inapplicable for fixation of cadre strength. Regulation of recruitment and the conditions of service. Subject to the provisions of this Act, the state government may by notification make rules. A. Specifying the different categories of posts in the different branches of public services of the state, the total number and nature of posts in each such category, and the scale of pay admissible to each such category. B. For the regulation of the recruitment and conditions of service of persons appointed to public service. This was the Section 3 as it was originally enacted. At that point of time, this Honorable Court interpreted this section to say that after coming into force of the 1978 Act, even stipulation of the number of posts in the cadre requires a rule to be made by notification, by interpreting Section 3(1). Justice Ravindran said. M.V. Dikshit versus State of Karnataka. That is, I'll please place a copy of that judgment also, my lords, M.V. Dikshit. Then, my lords, proviso, it required only where it is concerning judiciary, consultation with the Chief Justice, High Court is required. Then, my lords, the power to make rules under subsection shall be subject to the following conditions. The rules shall be made after previous publication for a period of not less than 15 days. Originally, it was 30 days. Then it was by amendment reduced to 15 days. Previous publication means draft has to be published, the objections have to be invited, all those things came. Then, my lords, where the consultations and all that. Thereafter, my lords, third proviso there, my lords may kindly see, that is the last of the provisos. Provided that nothing in clause A shall apply to the rules specifying the number and nature of posts. Therefore, clause A is by making of a notification and all that. That was taken away. This was taken away from 6th May 2010. Thereafter, no notification is required, nor any rule making is required. It is by an executive order. How the executive order comes into operation is state government feeling the need to establish a court proposes to the High Court saying that for this matter a separate court is required, or in Ramnagar district there are large number of matters pending, therefore a court is required. The initiative can come even from the High Court. From where the initiative comes is not important. Ultimately, proposal should come from the government. Then High Court accepts that proposal and says, we agree that a separate court can be established or an additional court can be established. Then the governor issues a notification. The governor means the shorthand form of governor is government. Government issues a notification that adds to the cadre strength. Nothing more is required.
One clarification.
Yes, madam. Yes, madam.
The power of the state government insofar as the High Court.
Yes,
The Chief Justice is the reference that we get.
yes, madam.
Then is it to say that the Chief Justice has the power?
Chief Justice has the power, but in the matter of establishment of courts, the government should agree, because ultimately government has to fund the court. Then whether to establish or not, Chief Justice is not bound to accept every recommendation of the government. Chief Justice can say, I will not. Particularly, my lords, in the matters involving financial outlay, the law has been this. Chief Justice writes to the government. Government normally should accept the recommendation of the Chief Justice. These days, my lords, when financial outlay is involved, even judgments in All India Judges Association are not implemented by the state government. Yesterday or a day before in our own High Court, a committee of honorable judges has been appointed by the Chief Justice to oversee the implementations, the recommendations of the second National Judicial Pay Commission. The law is this, my lords. The government should generally accept the recommendations. And generally, they delay the acceptance. I can cite only one example. When Lordship Justice Thakur was learned judge of this court, a committee of 3 honorable judges was appointed to go into the service conditions of High Court employees. Their grievance was, now certain people were on establishment of the administrative tribunals. Some employees of our High Court were deputed to the tribunals. People who went to Central Administrative Tribunal, as also state admin, they were given option for absorption there. Employees of the High Court who went to CAT, they opted for absorption. On such absorption, they got central pay scales. Whereas people who did not go on deputation and continued to work here, they were in state pay scales, and the disparities became so much. If I remember, in 1996 or 97, that committee was appointed. Then I appeared before that committee of 3 honorable judges, pleading the case of employees of our court for parity for migration to the central pay scales. Ultimately, the migration order came in the year 2018. Though the recommendation was there, because it involved financial outlay. Therefore, my lords, generally the Chief Justice has to recommend first. Then government accepts. And when the government accepts, and the notification issues in the name of the governor, that is the addition to the cadre string. No separate notification is required. And that is why 703 page 2001 notification is there. Thereafter, I don't know when these notifications stop. Huh? Amelilla. Another one. There are, yes. Yes. Really, ಏನು ತೊಂದರೆ ಇಲ್ಲ, ಮಾಡ್ತೀವಿ. ಹ? ಏನು ತೊಂದರೆ ಇಲ್ಲ. ಹೊಸ್ನಾಗ. 2010 ಅಲ್ಲ? 6/5. Yes, ma'am.
Proviso under 3.2
Yes, ma'am.
stated. Proviso under 3.2, the last proviso.
Yes, ma'am.
Provided for the nothing clause shall apply to use restraint, number and nature of force. The proviso only to 3.2a.
3(1)(a). What happens is, this is power to make rules is 3(2). How that power has to be exercised by this one. 3(1)(a) includes prescribing the number and nature of posts. That has been taken away from the purview of the entire section. It is, but they say, my lords, nothing in this clause shall apply to clause A. That is whether previous publication is necessary. It appears so, my lords, because rule need not be made. There are two ways of interpreting it, my lords. No, my lords, the notification establishing a court is published in the official gazette.
Power to make rules in one shall
Yes.
have these conditions.
Yes.
Therefore, in fact, it will apply.
No, my lords, there are two ways of trading it, my lords. If it is treated only as a proviso to subsection 2, then procedure need not be followed, but notification is required to be issued. If it is treated as a proviso to entire section, then notification also need not be issued. But since we are dealing with the cadre of district judges, where common sense tells us that for one court there should be one judge at least, then notification, insisting on a notification, would be insisting on a hyper technicality, is my respectful submission. Even if my lords were to view that the proviso is only applicable to subsection 2 of section 3, which I quite see is a possible interpretation. Because there are two provisos to subsection 1, there are three provisos to subsection 3, subsection 2. In such a case, even if proviso below subsection 3 2 is treated as applicable only to subsection 2, the position that would emerge is making of a rule with previous publication will go, but issue of notification remains. But since there should be one judge for one court, saying that, and establishment of a court is notified always. Kindly remember that. Establishment of a court is notified. Therefore, addition of one post to the cadre strength of district judge is also notified, is my respectful submission. The position may be different when it comes to stenographers or yes, ma'am.
Subject to the provisions of this Act, the state government may rules A, B.
Yes, ma'am.
A says specifying category, different categories of courts in different branches of public service of the state, the total number and nature of courts in such category,
Yes,
the
ma'am.
scale of pay is to be done by the state government.
Yes, ma'am.
Proviso, if read now,
Yes, ma'am.
provided that in respect to the officers and servants of the powers of the state government are insufficient, to be exercised by the Chief Justice of the High Court.
Yes, ma'am.
So it could be this, that 3(1)(a),
Yes, ma'am.
powers which are vested with the state government, is to be exercised by the Chief Justice, and so far as specifying different categories of posts in different branches of the High Court.
Yes, ma'am.
One way.
Yeah, that is the correct manner, because in the High Court employees, notification is to be issued by Chief Justice. But that will be after previous consultation, I told, because the financial powers and all that. But in respect of district judges, ultimately, it is to be made by the state government only, though in consultation with the High Court. Because Article 233 says, power to appoint district judge vests with the governor. But such appointment can be made by the governor only in consultation with the Chief Justice. 233.
Just saying one way.
Yes, sir.
When the appointment power is with the under 232. However, suppose I'm just throwing it an argument.
Yes, sir.
That under 2(3), the power to specify different categories of posts in different branches, which is otherwise available only with the state government, by virtue of the proviso to 3(1),
Yes, ma'am.
is vested with the Chief Justice.
No, Manoj, that is only in respect of High Court employees. Kindly read that proviso.
It says officers.
Officers and servants of the High Court.
Officers,
District judge is not a servant of the High Court.
officers is defined.
No. Officers and servants of the High Court. It is different from officers and servants of the district judiciary. Officers is not defined, or servant is defined. Here, in the second proviso to, in the first proviso to subsection 1, reference is only to the employees of the High Court and not, it does not bring within its ambit district judiciary or I cannot use the no lower judiciary. I don't know because other civil judges. That is the reason, my lords, all the service rules in respect of High Court employees is made by the Chief Justice. All the service rules in respect of district judiciary is made by the governor in consultation with the Chief Justice. Huh? 229 of the Constitution. My lord should kindly turn to Article 229. The position becomes clear, my lords. Officers and servants and the expenses of high courts. Appointments of officers or servants of a high court shall be made by the Chief Justice of the court or such other judge or officer of the court as he may direct, provided the governor of the state may by rule require that in such cases as may be specified in the rule, no person not already attached to the court shall be appointed to any office connected with the court, save after consultation with the Public Service Commission. Subject to the provision of any law made by the legislature of the state, the conditions of service of officers and servants of a high court shall be such as may be prescribed by the rules made by the Chief Justice of the court or by some other judge or officer of the court authorized by the Chief Justice to make rules for the purpose. That is the meaning to be attached to the.
The administrative expenses. It includes officers and servants.
And then clause 3 of Article 229 says, provided rules made under the clause shall, as far as they relate to salaries, require the approval of the governor. That is what I said, where financial outlay is involved. This also has been, this proviso also has been interpreted by the Supreme Court. Supreme Court said, because it requires financial outlay, this proviso is made. It does not take away the independence of the judiciary. And they read into that proviso, generally the government should accept the recommendation of the Chief Justice of the High Court in the matter of salaries and allowances. Now, of course, without without any law, Supreme Court has appropriated to itself the power to fix the service conditions of the district judges. That is a different matter. And normally, 3 Chief Justice and 2 judges in line to become Chief Justice are part of that bench. Invariably. Second proviso to 3.1. Again, it leaves the rulemaking to a special board consisting of Speaker of the Legislative Assembly and Chairman of the Legislative Council, because they are the custodians of the House.
Yes.
Therefore, my lords, when a district court, even a court of district and session judge, it cannot be because there will be a court of district and session judge when it is established, and governor issues a notification establishing that court. It goes without saying that one post of district and session judge is created. Insistence on a notification then would be, what I would say, a Victorian exuberance which a democracy can ill afford. It would be, my lords, chasing a shadow, ignoring the substance. And of course, there are some cases where we look at the shadow because when we are afraid of looking at the person. But I don't think that can be. Lords, could I continue now? Next. Yes, my lords.
Friday there will not be sitting.
Huh?
Now, Friday appears to be difficult.
Yes,
Friday
ma'am.
afternoon.
Yes, ma'am.
So whether Tuesday afternoon.
Tuesday, in fact, I wanted to suggest, my lords, if my lords have it on Tuesday and Thursday, the matter can be concluded before vacation.
Thursday there's some difficulty. Special court I have some.
Wednesday also could be there, my lords.
We'll have it on Tuesday, we'll see.
Very well, my lords.
Tuesday appears to be doable, other day we can't say.
That is simple.
So we'll do it on Tuesday
Very well, my lords. I'll do it.
at 2:30 on Tuesday.
On that day, I would, sorry, today's deficiencies, I would make them, my lords, the copies of the judgments and all. Sorry, my lords, my judgment failed about the time. That is,
The one clarification,
yes,
whether the word officers,
yes, my lords.
now servant is employee.
Yes, my lords.
Whether officers, I'm just
Yes,
asking.
yes, members. Yes.
Officers can include judges. Just think about it and let us.
Rule 393.
229.3, I think, provides an answer, but I'll clarify. I'll
Yes.
go through and I will apply my mind to that and clarify.
Even under 3(2), whether the word officers can include
But
judges.
that my first submission to an answer to that is, it speaks of officers of the High Court. District judge is not an officer of the High Court. That is my answer. But anyway, whether I'll get a better answer, I will investigate and come back.
The for the hearing ಅಂತ ಹೇಳಿದ್ರು ಅಷ್ಟೇ. ಮತ್ತೆ ಅವ್ರು ಮುಗಿಸಿದಂತ ಹೇಳ್ಬೇಕಾ? ನಾಗಾನಂದ್. Learned Senior Counsel Sri S.S. Naganand had appearing for the High Court had advanced his arguments. Full stop. The arguments of Learned Counsel Senior Counsel P.S. Rajgopal remains inconclusive. Relist the matter on Tuesday at 2:30.
Great.
We want the High Court also to file the written submissions, first installments.
Very well.